and compilation 3C.
Is the PDF page?
PDF 34. I know that it is the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The Speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension, essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the House are suspended when his motion is under consideration for his removal. Now, my Lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well not scuttle the entire removal procedure. I'll briefly remind your Lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my Lord, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds. This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd June 2022, Sunil Prabhu, acting as Chief Whip of the Shiv Sena Legislature Party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri Eknath Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the Chief Whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. For that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule. For what? For not attending the meeting. Now, my lord, the contention of the petitioner is that the notices issued on 21st and 22nd were validly issued and were binding on all members of the Legislative Assembly. Our contention that the two resolutions of 21st and 22nd were illegal for the following reasons. Prabhu had been removed as the party whip by 34 MLAs of the Eknath Shinde group on 21st June itself. After he had been removed, he issued that notice or notices. The notices were therefore without jurisdiction. Now, very important. Moreover, it is well settled that a party whip can only be issued for actions on the floor of the assembly and not outside the house. The party whips of 21st and 22nd June were misconceived and illegal insofar as their content was concerned. Now, my lord, over here, there's a new document which is not before your lordship, but we have filed it just now regarding the Legislative Assembly debates, the parliamentary debates pertaining to the 52nd Amendment in 1985. I'll just read the speech of one member. What is the reference? But it's the last document on record.
Last document means where? Where is it?
Is it scanned?
Well, we just filed it in the lunch break. I'm sorry, my lord. We just discovered this document.
All right, you can just refer to it.
Where is it? Well, Lord, this is the speech. What happened, my lord? And there's another provision.
Who's the speech by?
By Sharad Dighe, one of the members of parliament in the Lok Sabha, who said this. Now, what happened was, originally, the bill had 3 provisions under 2. 2A as it presently stands, 2B as it presently stands, and 2(1)(c). There was a third provision. That third provision permitted disqualification for activities outside the house. Now, I haven't got the exact provision, but I'll get it by this evening and tender it. Because we only just discovered this. The third one was removed. By debate, it was deleted. 2(1)(c) was deleted, and your lordship will just see one. It's at PDF 38. Your lordship can just note. Where is the marked part? This is what he says. This is what Mr. Dighe says in the parliamentary debates of 1985. I'm reading from the parliamentary debates. Now, there have been several clauses in this bill, and I am happy that the law minister has also announced that 2 of the clauses are to be amended. As far as clause 2, subclause 1, paragraph C is concerned, that has to be deleted, and paragraph B has to be amended suitably. It was very much necessary to delete paragraph C because if a member has to be expelled from a political party in accordance with the procedure for anything done outside the house, it would have created several practical problems, and it would have given a handle specially to the bosses of smaller parties where this paragraph would have created some difficulties. Therefore, the main principle of this disqualification is that for something which a member does in this house, in the presence of this house, such as voting against the party or abstaining from voting against the direction of the party. Now, this is something which is proved beyond doubt. No other inquiry is necessary by any other committee or anybody else. So it is very clear that any act done by a member in the presence of a presiding officer, namely voting or abstaining from voting, would entail him to this disqualification. So there is no injustice, no chance of any injustice being done, nor is there scope for any doubt whether he has committed that act or not. Therefore, from that point of view, acts done outside the house have been deleted or are proposed to be deleted now because there would have been the question of proving them. Some doubt may arise, and there will be the question of giving a hearing to the member, and also the rules of natural justice would have to be followed. So the whip squarely applies for disobedience on the floor of the house. It doesn't apply to acts outside the House. This is not to say that 21A is out. 21A is still there.
But isn't that on the merits of the disqualification
exactly-
petition?
Where does
Yes,
all
that's
this add up
This
to?
wouldn't really help you
But
at
right
all.
now, I'm not on the.
Because therefore your contention would be that, well, the disqualification was not attracted. But even assuming that is so, that's the jurisdiction of the speaker.
Yes, your lordship is right.
It's exclusively
That-
within his
So
domain.
therefore, what is being done in this case, or proposed to be done, because it was never acted upon, what was proposed to be done by the letter seeking my disqualification was to bring in through the back door a 21A situation, which is because this was an act outside the House, which is prohibited. 21C, legislative intent was to take out 21C.
Then, Mr. Jetmalani, in that sense, Mr. Sibal's argument was that this was a per se disqualification. You're now dealing with a per se disqualification on merits. Your argument all along has been, the argument of your side has been, don't go into the per se disqualification argument at all because it lies within the domain of the speaker to decide. Now you're really, by going into the merits.
Actually, this is purely.
No, my lord, at the moment, I'm not
Your
at this moment, I'm not on the disqualification petition, which I will
And
come
then
to.
you are inviting us to go into Mr. Sibal's argument as to whether there's a per se disqualification.
But I'm not.
He's right, he may be right on that.
But at the moment, I'm not on the disqualification petition. I am on the two letters which are sent to me. Please see that.
Well, why should we
Because-
go into the merits of the disqualification at all? Because once you say
All right.
that disqualification lies exclusively within the domain of the speaker, then perhaps then it would be internally inconsistent for you to argue that, well, there was no disqualification.
There were two grounds in the disqualification petition, and they were both based on this letter.
But you
So
can very
that
well
would have
also
been your-
stop at the place where you can very well say that as it is the prerogative of the speaker to consider, we will, why should we? That
It
is
can
not
stop.
stand, mister. That
It can stop there. Your lordship is absolutely.
Don't try to justify whether there was a disqualification or not.
I agree. I don't need to go that far, but since those two letters were the very grounds of my disqualification,
Okay, Mr. Bijay.
All right. What is the
Proceed
next
further.
point now,
What
Mr.
is
Jet?
now the next one.
Mr. Jetmalani, what was the page number since we've got that downloaded, airdropped to us? Just tell us the page.
I'm saying Nabam should be
No, no.
reaffirmed.
The speech.
On last debate.
The debate that you referred to of 85, it's been airdropped to us just now. Just indicate the page, please, for us.
Yes.
What page?
It's been said
Page 38. Page 38.
38, all right.
Now the second. Now don't bring these serious matters.
What's the next point?
The next point is that the fact of 34 MLAs being part of the real recognized Shiv Sena, and this is more substantial, was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date,
Yeah, but-
which clearly spelt out
Mr.
that
Jetmalani, which part?
I'm reading now at P11.
P11.
P11. Is written.
What happens?
Page 11.
Yes. The second point.
All right.
That the fact of respondent 34 MLAs being part of the real recognized Shiv Sena party was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelt out that they were the real Shiv Sena party. The Deputy Speaker ought inter alia to have desisted from proceeding any further with the disqualification petitions, as it should have been obvious to him that there being now two groups, each claiming to be the recognized Shiv Sena, the dispute on the issue was a matter which was squarely within the jurisdiction of the Election Commission under Clause 15 of the Symbols Order. So, my lord, the proposition here is that once the claim is made that we are the real Shiv Sena, as opposed to a second group, that we are, in other words, that we have both legislative and organizational majority or heft, the Speaker should desist from proceeding further with a disqualification proceeding pending an adjudication by the ECI, because the Speaker can only go into legislative matters. He cannot go into the organizational situation. In the facts of this case, I may say one more thing. In the facts of this case, all the MAs, MLAs in this case, all MLAs, this is part of the party constitution. All MLAs, all MPs of every house are ex officio members of the Pratinidhi Sabha, which is the supreme organizational body of the Shiv Sena. So even if the speaker in this case were to adopt the twin test, the second one being the organizational issue.
But Mr. Jeffrey, this point Mr. Kaul has also already made, that it is not the case of your side that there was either a split or merger in the political party. The contention was that a rival faction in the Shiv Sena represented the real Shiv Sena.
Real Shiv Sena.
And this has now been found to be true and correct by the subsequent
by the ECI.
Right.
So, my lord, a question was posed.
But therefore, Mr. Kaul has made that point. I don't think you need to. So
the question was posed whether what should be the conduct of the speaker when such a situation has been pointed out to him.
You are saying
not a split.
You are saying that he has no jurisdiction at all.
He has no jurisdiction. He must submit to the jurisdiction of the ECI. He should desist from pursuing the disqualification proceedings further. Now, my lord, we come to the very important aspect of this matter, which actually takes out the foundation of the applicability of Nabam Rabia. Now, on 24th June 2022, the Deputy Speaker wrote an email to the advocate for the 34 MLAs in response to their notice of 21st June under Article 179C, stating that he could not recognize the email ID from which the notice under 179C was sent. Therefore, he would take no further action until and unless the genuineness or veracity of the said signatures on the letter or the email ID is ascertained. So, in fact, he ignored Nabam Rabia, or ignored it on extremely specious, frivolous grounds, that I could not recognize it and I would wait for verification. That verification was never communicated. So where is Nabam Rabia even involved in this case? You either ignored the dictates of a constitutional bench judgment, or alternatively, you ignored it, you rejected it on the basis of extremely flimsy grounds. But in any event, you never acted upon it. That notice under 179C never ever obstructed the speaker from what he went on to do, because he contemptuously ignored it on specious grounds. And he disobeyed the then mandate. Nabam Rabia was good law and he ought to have obeyed it. So now this is the real nub of the issue, when the whole case is one of deemed disqualification. And Nabam Rabia is invoked because of that notice under 179C. That you hindered me in my job as speaker by issuing that notice, notwithstanding the fact that Nabam Rabia was good law. In fact, you were not hindered. Factually, you were never hindered, because you tossed my notice into the dustbin. So that's the end of anything further. Your deemed disqualification doesn't apply now.
Right.
Okay.
Then, my lord, something very important starts from 25th June. On 25th June, the Deputy Speaker issued summons. Now, my lord, all along, we are told that there are 39 MLAs. Your Lordship has made all those calculations on 39 MLAs. Now, my lord, there's a serious issue here. The Deputy Speaker on 25th June issued summons to 16 MLAs only, informing them that a disqualification petition has been filed against them, which was served along with all annexures only on 16 MLAs. Now, for the first time, they inform us. Remember, this is a very serious issue. First time they inform us is on the 14th of July, when a disqualification petition allegedly dated 27th June. Now, I will point out the pleadings very briefly, or I'll just point out there has never been any reference to a 27th June disqualification petition. Admittedly, it was not served on us. Admittedly. The so-called 27th June petition for disqualification of the remaining 23 MLAs, apart from 16. Lordship remembers there were 39 MLAs. 16 MLAs has been the theme throughout. Even during the hearings in the Supreme Court, which they've carried against. The hearing in the Supreme Court on the 29th and the 29th, when they moved the Supreme Court to challenge the governor's decision to call for a floor test, even on that date, the reference was only to 16 MLAs. But in arguments, it is being sought to portray that all 39 MLAs were received disqualification notices. Now, there's a second aspect here, a legal issue. The Lordship turns to page 12. Regarding that notice, regarding the disqualification petition. In every pleading, your Lordships will note that contrary to what is being suggested to your Lordship, in every pleading, there is no mention of the remaining 23 MLAs. That is a matter which has misled this court. I had no idea myself till it was pointed out. I assumed that was always 39 MLAs. But it has throughout been, and there's a reason for that. There's good reason why they only served these disqualification notices and petition to 16. Because they wanted to split the two camps. 16 still made it possible for them to survive a majority on the floor of the House. 39 most certainly didn't. So till the last minute, they only talked about 16. It is only after the new government came into existence, the new speaker was appointed, the new government came into existence, that they referred to 39 MLAs.
We'll just get up for 2 minutes.
Yes, sir.
The Chief Justice of Kenya has to have other meetings, and we'll come back in 2 minutes. So according to it was only after the new government came.
For the first time in a petition, your Lordships may note of 8th July, yes, which they filed before this court. In that 8th July petition, they said 39 MLAs totally, and they referred to a disqualification petition of 27 June, which nobody was served, and they never referred to any of their earlier pleadings. Now, this whole exercise on 16 MLAs would never have taken your lordships so many days, unless you all wanted to revisit Nabam and all that. But on facts, if they had been fair and said there were only 16 MLAs disqualified at all times and not more, the situation was purely academic. And the reason is malified. Why this division? The reason is malified. You wanted to split the two. You were hoping that you would get back 23 of them and your majority would survive. That is why only 16 MLAs. But when the government fell, that necessity didn't arise. When that government fell, that rationale had gone. Now you wanted to topple the whole government. On this disqualification issue, a second major fault on the part of the speaker. He gives me 2 days to reply. Now, that is very important. A little factual digression is necessary, but it is a little law and a little factual, because this is very important. But this reveals malefice on the part of the speaker in the extreme. Sorry, deputy speaker. Incidentally, there was no speaker for 2 years in Maharashtra.
There was no speaker at all.
Yes.
The deputy.
Now, my lord, within 7 days, please see Rule 73B. It said PDF 129 JC1. Sorry.
What does Rule 73B say?
Statute compilation.
15 days, right?
7 days.
7 days.
Sure.
Okay, that's fine. We can go. But that's all I want to point out. Really, it's 7 days. But what is important is, whereas the Maharashtra Assembly rules may be subject to Article 212, which says irregularities of procedure can't be looked at by a court. Mere irregularities. If it's a serious irregularity, the latest judgment of Justice Khanvilkar's 3-judge bench says that if it involves a question of natural justice in another Maharashtra Assembly case, then it's escalated to the level of a constitutional provision which must be obeyed. And the violation would be 1421, etc. But as far as the disqualification rules are concerned, and when I talk about 73B at page 12, this is not part of the assembly rules. This is now part of the disqualification rules. And these are framed under paragraph 8. And my submission is that these rules are mandatory, and any breaches of them by a speaker / deputy speaker are not immune from judicial review as per other procedural regulations under 208. Whose effect are diluted by 212. About just 2 paragraphs of 2 different judgments. Actually, I've set out, but your lordships may just see Kyoto's judgment. PDF 129, judgments compilation 1.
You are referring to these Kyoto and Shrimant to say that principles of natural justice is mandatory. There's no dispute on that. Take that point.
Not just that, it's a specific reference to the. I'll just read one paragraph. The lordships will see what I'm getting at. Para 97 in Kyoto. page 129, PDF 129.
Para 97.
Yes. It's not just the rules pertaining to natural justice. Paragraph 8 rules are all immune from the dilution provided by Article 212. Because these are, I'll tell your Lordship, the reasoning comes there. Please see that. That's why I want your Lordship to just see it. The reason is contained in paragraph 96. That apart, even after 1986, when the 10th schedule was introduced, the Constitution did not evince any intention to invoke Article 122 or 212 in the conduct of resolution of disputes as to disqualification of members under Articles 191 and 102(1). The very deeming provision implies that, that the proceedings of disqualification, the deeming provision says these shall be deemed to be proceedings of the House. The very deeming provision implies that the proceedings of disqualification are in fact not before the House, but only before the Speaker as a specially designated authority. The decision under paragraph 6(1) is not a decision of the House, nor is it subject to the approval of the House. The decision operates independently of the House. A deeming provision cannot, by its creation, transcend its own powers. There is therefore no immunity under Articles 122 and 212 from judicial scrutiny of the decision of the chairman, speaker or chairman exercising power under paragraph 6(1) of the 10th schedule. Now, my Lord, 6(1) includes the whole gamut of procedure, starting with the petition for disqualification. The entire gamut of the procedural provision, 6(1), and your Lordship may then just see 8.
Para 6(1), right?
It says, subject to the provisions of subparagraph 2 of this paragraph, the chairman or the speaker of a house may make rules for giving effect to the provisions of this schedule, and in particular, and without prejudice to the generality of the foregoing, such rules may provide for, and your Lordships may kindly turn to D. D. The procedure for deciding any question referred to in subparagraph 1 of paragraph 6. So when my learned friends talk about the Supreme Court intervening with that notice period, which is prescribed, I'm talking about the 27th decision, which is prescribed under rules framed under 8, i.e. 7(3)(b), the Supreme Court was fully justified. The bench of that day was fully justified. Apart from the fact that it ill behoves a legislative assembly to say that rules framed by it under a constitutional provision can be blindly ignored by it. They're the legislators. If they set that precedent, God save the rest of the country. Now, my Lord, even in the latest case of Shriman Patil, I'll just read it from my note, the relevant provision. Even the latest case of Shriman Patil, hello, that was the, I'm now at the bottom of page 12, on D. I'm on D. Even in the latest case of Shriman Patil, well, this was the, I believe, the Karnataka Assembly case, where time for a reply to a disqualification petition was contrary to the rules of the Karnataka Assembly, the court held in paragraph 190.7 as under. Our findings on allegations of not granting specific time in all the above cases are based on the unique facts and circumstances of the case. But actually, after Kyoto's case and the elevation of those rules under paragraph 8, there should never have been any leniency in time given to file a reply to a disqualification notice. You are affecting not only the MLA but his constituency. It should not be understood to mean that the speaker could cut short the hearing period. The speaker should give sufficient opportunity to a member before deciding a disqualification proceeding and ordinarily follow the time limit prescribed in the rules of the legislature. Well, an exception was carved out in that case, but even so, the principle was reaffirmed that the rules are mandatory. Now, my lord, on the one hand, a disqualification petition is given to us. The speaker ignores Nabam Rabia. 2, he gives me a 2-day instead of a 7-day period. 3, what happens? Now, my lord, kindly see. I am now on 13, and this is a very important aspect. While those disqualification proceedings are pending, everything is done to prevent me from coming for a hearing. Please see. My lord, I would request your lordships, this is the prelude to my petition before this honorable court on the 27th. This is what actually happened. I did pray for staying of the disqualification proceedings, and in my respectful submission, even had a quia timet, my learned friend Mr. Kaul pointed that out, even if a quia timet injunction had been granted restraining the speaker from pursuing the disqualification proceedings on the ground that a constitutional provision, i.e. 179C, was being ignored, because Nabam Rabia was the law at that time. Right? Even if they had done it, which they didn't do, there would have been nothing wrong with it. What they actually did ultimately was only confine the reliefs granted to police protection, and I'll come to your lordships why, and the time period extension from 7 to 14, from 2 to 12 days. Now, my lord, your lordships will kindly see the threats that were given to me. First, your lordship will kindly see, and this is very important because I couldn't come. They prevented me from dealing with my disqualification application. First, they ignored the 1979C, they chucked it to the dustbin. Secondly, they gave me practically no time, 2 days. And then, kindly see the threats that were issued to me. But the first one your lordship may see is 24th June.
Not necessary to read the threats.
You've relied on para 97 of Kyoto. You've also distinguished.
But very important.
We take it that it was compelling for you to come to
Yes,
the court.
but I'll summarize what those threats were. First of all, my lord, security to, I was out of Bombay. Security to my family members was withdrawn. Death threats were being given, security was withdrawn, and publicly there were pronouncements of the leaders of the Uddhav Thackeray faction that if I come back to Bombay, if I come back to Mumbai, my bodies would be sent straight to a crematorium. That's the nature of threats. In view of that, I had to move the Supreme Court for multifarious reliefs. Out of those, on the 27th, only 2 were granted. There were serious death threats. My lord, one of them, a gentleman called Tanaji Sawant, an MLA, I think he was the minister of the government when the government was united. His office was burnt. It was the most serious situation at that time. And kindly see the response. Now, I don't want to tread on the solicitor's province. Your lordship may just see the letter of the governor at that time. Because, my lord, this shows the kind of information that the government was always receiving, continuously receiving, which ultimately culminated in his decision to call cause of law test. Page 306 PDF.
Sir, it was read and reread. That letter to the governor was read and reread. Correct? So we know that these are the things. Correct. Earlier there is a threat, and earlier there was a coalition government. There is a breach. Everything has been read, Mr.
No, this letter pertains to the governor saying the situation is extremely serious.
Correct, that we have.
Please give them security. Look, we're talking now about a speaker and a government that ignores a constitutional mandate. I just want to see what is happening. The thread. You throw out the leader of the legislature party. He gives you a notice fearing disqualification under 179C. You ignore it on completely specious grounds. Then you serve me the next day. You serve me a disqualification petition for 16 MLAs. Divide and rule. When I get that disqualification petition, in the notice you say, reply within 2 days. Contrary to rules, mandatory rules. And finally, you prevent me from coming to Mumbai. I'm entitled to a hearing. You prevent me from coming to Mumbai with death threats and withdrawal of security to my wife and children and burn houses. Conduct of the speaker, therefore, needs to be, that's the only reason why, notwithstanding that the fact that the factual basis of this case doesn't warrant any legal relook at Navam Beria, because as I said earlier, Navam Beria was never an issue because the notice was never ever acted upon. Notwithstanding that fact, restrictions circumscribing misuse of power by the speaker need to be imposed. And Justice Mishra's judgment in Navam Beria needs to be reaffirmed. So I'm not going into the governor's letter.
What else, Mr.?
About under Article 164(2), my learned friend talks about a very high constitutional principle. He elevates the entire conspectus of this case to the evil of defection. So the evil of a speaker and a government hell-bent upon power is an even greater evil. But there's a constitutional principle, which the Lordship, just look at G at page 14. Well, the principle emanates from 164(2), which says that the Council of Ministers are collectively responsible to the Legislative Assembly of the state. Well, what does this mean in practice? It means that when the Council of Ministers collectively lose the support of the majority of the House, they have to step down. So, my lord, much higher than the evil of defection is the principle of majority rule in this country. That is paramount. And the principle of majority rule is to be found, there are judgments on 164(2), is to be found in 164(2). That when you, and that's why the governor is given the right to form a new government headed by that person, not headed by a political party, headed by that person who commands the majority in the House. And he has to ignore, says Rameshwar Prasad and Shivraj Chauhan, which my learned friend Mr. Kaul read out. He has to ignore the fact of any potential disqualification of those members who might support the new government. My lord, at page 15, the Lordships may note point 2, H, main heading H, Supreme Court refused to grant stay on floor test. And 2. So these two, I'm not going to read these petitions, but they say there are only, on 29 June, and they say that there are only 16 MLAs disqualified. That is the last date on which anything could have affected them. 29 June itself, the petition was for disqualification of 16 MLAs. As I said, the 16 MLAs issue came only on, and till today we don't know the number of that petition. It was allegedly filed. It was allegedly filed before the Deputy Speaker. We do not know the disqualification petition number till today. It is placed before your lordships. What's the page? I'll just give your lordship the page. Never served upon us. But the contention is 39 MLAs all along. Now, just the last three points very briefly. At page 16, KLNM, sorry, JKNL, the flaw test was never held. Although there's some limit to causation in the law. To say that Mr. Uddhav Thackeray resigned because of all that went before is, my lord, stretching credulity to the nth degree. He resigned because he knew he had lost the majority. My lord, there has to be, this is too remote a cause in law for that to be a consequence of all that happened before. He voluntarily stepped down. My lord, JKL, I'll just read it out quickly and then I conclude. The question of deemed disqualification. There is no such concept as a deemed disqualification. Disqualification has to be actual, and there is a mandated procedure for disqualification proceedings. My lord, I request your lordship to just indulge me and read Rule 7.7. This is under the disqualification rules, not now under anything else, and not under the assembly rules.
Page 10.
7.7, your lordships were referred earlier. Sorry. The lordships were referred earlier to 7.3b, which was that notice period. Now, 7.7 is the rest of the procedure. Please have a look at it. And for the question of deemed disqualification. It's page 12 of the statute compilation volume.
Yes, sir.
This must be quite threatening.
Huh?
Our presence must be quite threatening.
Acha, you said presence.
Presence.
We have heard patience.
No.
No, we thought our patience.
We are yet to follow. Then.
No, it's okay.
7.7.
You are on 7.7.
7.7. The procedure which shall be followed by the Speaker for determining any question, and the procedure which shall be followed by the committee for the purpose of making a preliminary inquiry under Sub-Rule 4 shall be, so far as may be, the same as the procedure applicable for the determination by the committee of any question as to breach of privilege of the assembly by a member, and neither the Speaker nor the committee shall come to any finding that a member has become subject to disqualification under the 10th schedule without affording a reasonable opportunity to such member to represent his case. There has to be a mandatory hearing in this matter. There cannot be a disqualification without a hearing. Therefore, to talk about a deemed disqualification in the absence of a hearing is to suggest this. Now, my lord, it is suggestive, my submission on this point, A deemed disqualification is suggestive of a contention that the reply of a delinquent MLA and the hearing which he has the right to before the Speaker are both empty formalities. It further suggests that the Speaker would be necessarily of predetermined mind and partisan bent. To deem disqualification, that means the hearing is an empty formality. Something which a litigant who claims to be upholding lofty ideals and unbiased procedure should be loath to canvass. And my Lord, equally untenable is the contention of dating back of a disqualification. The judgments in both Rana and Patil are no authority for setting the clock back on all events that took place up to the date of the action which made an MLA liable for defection. A plain reading of those judgments, well, Mr. Kaul has read them out, clearly reveal, see for example, Rana's case in paragraph 34, that the Speaker has to decide. That's all that Rana is authority for. The question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies a whip. It is really a decision ex post facto. The phrase ex post facto does not entail retrospective operation. The argument also completely ignores Articles 189(2) and 191(2) of the Constitution, both of which clearly indicate that an order of disqualification only had retrospective effect. Particularly important, my lords, is 191(2), which says he shall be disqualified when he is disqualified. It has only, disqualification only has prospective effect, not retrospective effect. And lastly, my lord, L, I've already taken this point, so I won't repeat it. But I am deeply grateful for a very patient hearing.
Only a couple of points, not to repeat anything. We have, I think, heard the same thing over time and again. But if your lordship may just have a note, we had filed it, and there are brief submissions which are put in the index itself. The points have been flagged, my lord. First point, my lord, if your lordship have got that note I. Hold on a second.
What aspects will you be dealing with, Mr.
My lord, I am dealing with the 3 or 4 aspects, my lord. One being on Nabam, my lord, very briefly, which is not specifically highlighted. Number 2, my lord,
42 pages.
Quixote para 122 with relation to 21B. And my lord, the 2 judgments which they have relied upon on the other side to contend, my lord, that there is a permissibility under the constitutional scheme for the court to deal with a disqualification petition directly. And the Karnataka judgment is, my lord, a Bible on not attending meeting constituting a disqualification under 2(1)A. Lord, I'm going to, with reference to para 122 of Kyoto, it is only 2 kinds of meetings, my lord, which fall under 2(1)B. This, my lord, the first point is, Nabam. And that, my lord, respectful submission is rule against participation of the speaker till the time, my lord, the removal resolution process is completed. My lord, if your lordship may come to the index, kindly skip the first one. My lord, there is a 1-page index.
Rule against participation.
So first point, your lordship may skip, the relevant dates your lordships have considered, noted down. I'm not reading anything from there. The first is rule against participation of the speaker. Kindly come to that at page 5.
Page 5.
And my lord, your lordship may take it, my lord. I'm not reading anything unless, my lord, your lordships have not seen any part. Now, my lord, rule 181 is against participation of the speaker. 179 is removal. Now, my lord, my respectful submission is 181 is founded on the basic principle of conflict of interest. That where you are personally involved or your personal action is or activity is going to be considered, you should remain out. This conflict of interest, my lord, gets elevated to the level of constitutional adjudication. A conflict of interest at the degree, my lord, even in executive functioning, if you have to now test it for a constitutional adjudication, the level would be far higher. So, my lord, there is a dissent, my lord, intra-party dissent which can be shown, and, my lord, the rule against participation of the speaker. And, my lord, this became a question in the constitutional validity challenge which was laid before this honorable court in Kyoto, that intra-party dissent is also a part of the constitutional scheme as well as democracy. How do you create a balance? This, my lord, is laid down, and I made a submission earlier, my lord. The proviso to 179C is the beginning of that rule against participation. Proviso to Article 179C is the commencement of the time duration. I'm sorry.
No.
Yes.
Time duration of commencement of rule of non-participation, and it gets concluded in terms of the main provision of 179C when the removal resolution is considered in the House. Kindly have a look at that, my lord. 181(2) is rule against participation. This is my submission, my lord, based on the conflict of interest, and when it is to be tested in the touchstone of the constitutional adjudication, because clause 6 of the 10th schedule is constitutional adjudication by the speaker. Now, my lord, if your lordship may kindly see the next page, at my lord, page 6 of my written note, para number 5, which reproduces the relevant portion of 179C.
Yes.
And I'm not going to read it, my lord. My respectful submission is that the proviso is the commencement of that non-participation period to begin, and main proviso to 179C is the conclusion when the removal resolution is taken in the House. Then, my lord, clause 11 from the legislature rule, Maharashtra legislature rules have been reproduced. I'm not reading it. I want to read, my lord, these 3 paragraphs again from Justice Honorable Mr. Justice, as his lordship then was not, Deepak Mishra's judgment, from para 235 to 238, which are reproduced at page 8 and 9. Now, my lord, when this conflict of interest is raised to the level of constitutional adjudication, and, my lord, the inter-party dissent is to be kept in mind, on the basis of which the validity of this entire schedule was upheld, 10th schedule was upheld. Kindly come to 235. The purpose of referring to the said article is to highlight the nature of participation of the speaker.
Yes.
I'm sorry, my lord, if I'm missing something.
No, yes.
The purpose of referring to the said article is to highlight the nature of participation of the speaker when the question of his removal arises. It is clearly different under the Constitution. He is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in the first provision, Article 179C, it is quite clear that it is the constitutional design that the speaker should not do any act in furtherance of his interest till the resolution is moved. Then 237. The aforesaid reasoning eloquently speaks of the power, position, and the status of the office of the speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and it has restricted it to the state, carving out certain extreme exceptions. It is because the speaker, while exercising the authority, jurisdiction, exercise the power of constitutional adjudication. The concept of constitutional adjudication as constitutional value in a parliamentary democracy and constitutional value sustain the democracy in a sovereign republic. The speaker is expected to maintain propriety as an adjudicator. The speaker, when functions as a tribunal, has the jurisdiction, authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. it must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purpose of sustenance of democracy, which is a basic feature of the Constitution. Manoj Rula, where speaking about democracy, has opined that democracy in India is a product of rule of law, and it is not only a political philosophy, but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role ascribed to the Speaker under the 10th schedule, it is necessary that Speaker as a tribunal has to have complete detachment and perceivable impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law, and the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally to suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule to the Constitution after intention to remove him from office is moved, the 14 days period being mandatory. The words all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of 10th schedule to sustain the robust vitality of our growing constitution, and it embraces the seminal spirit of rule of law that control all the powers, even the prerogative powers. So, my lord, therefore, this is how, my lord, the court brings in a balancing between these two, my lord, apparently areas which may be in conflict with each other, but your lordships, my lord, brought an interpretation to ensure that it is a smooth functioning. Now, my lord, this is founded on the principle of elimination of conflict of interest. And, my lord, that conflict of interest, when it is required to be demonstrated in a process of constitutional adjudication, your lordships laid down the duration of rule against participation of the Speaker from the date of issuance of that intention of notice of moving the resolution and its completion when the resolution is moved, and, my lord, whether it is sustained or it is not sustained. So that's the first respectful submission, my lord. Does not require any fresh look, because these reasoning is very, very sound, my lord, and is based on the principles which have stood the test of time. Now, my lord, if your lordship may then come to kindly move a little ahead on the next part of my note, my lord. My lord, Rana was pressed time and again with utmost respect to the other side. Please see Rana. Rana is a judgment which clearly reveals and clears the way for entertaining a disqualification directly by the courts. My lord, Rana is a case, my lord, and I will only make one line submission here, which has also been made earlier. The original disqualification petition is considered by the Speaker. It is then met a fate of its non-sustainability by the High Court. The matter when came to your lordship, no, your lordship then said, now there is no need to remand and we will rule on it. To rely on this judgment to say no, it gives a permissibility to the other side to raise a submission that the Speaker's jurisdiction should now get vested with the courts, and courts should come under an obligation to consider such a petition at the threshold. My lord, is not permissible. It, my lord, it would not deserve any approval by your lordships. My lord, page 13. There cannot be and should not be any deemed, my lord, disqualification. My lord, civil consequences, compliance with principles of natural justice, prejudice caused on the removal of an elected member of the House. My lord, it would be, with utmost respect to my friends on the other side, would be preposterous to even suggest that when a particular action can have such consequences that you remove an elected member, inflict an election again on the same constituency. Can there be that there is no notice and hearing? Because, my lord, to say that there is a deemed disqualification is making a submission of complete elimination of any process to be followed before giving that, my lord, position. No process to be followed. If a gentleman, according to that test, commits an act, he must go home straight away, whether elected by a constituency of, say, 20 lakhs people. My lord, MP constituency now between 16 to 20 lakhs. So the expression of their will toward the democracy must suffer a deemed removal, a negation totally, or totally unknown to any civilized society norms. Forget the constitutional scheme. The suggestion itself, my lord, with utmost respect, is preposterous. Should not deserve, my lord, even to be entertained as an argument. And, my lord, only thing which I want to rely additionally, a judgment of 3 judges, my lord, of your lordships, which I have cited, my lord, at page 13, para 7. Where, my lord, leading evidence in a 2-1A petition, your lordships have remanded it back that full opportunity, including leading of evidence, would flow from 2-1A. My lord, this is 2022 2 SCC 759. A short judgment, my lord. I'll leave the copy with your lord.
Manipur judgment.
I'm sorry.
Manipur judgment.
Yes, my lord. Now, my lord, after that, I want to read 122 in this background, my lord. We start from page 14, 122 of Kyoto. My lord, intra-party dissent was one of the argument to, my lord, to establish unconstitutionality and invalidity of the 10th schedule. That one of the rights of elected candidates is to speak against their own party if need be. That itself is a part of democracy. That how much I can speak on various large public interest issues within my party or outside against my party. Can this be curtailed totally in the name of party discipline and embarrassment to the party? Can it be curtailed totally? Should it be eliminated? My lord, your lordships upheld the validity and kindly make a note of para 44 of Kyoto, 17, 44, 121, 122 and 123. Let me repeat, my lord, 17, 44, 121, 122 and 123. Now, my lord, your lordship may also make a respectful, kindly consider a respectful submission. If your lordship may kindly see clause 2 of the 10th schedule, which is reproduced at page 14. Lord, the grey area now only remains is 2-1A. 2-1B, your lordships have decided in Kyoto 122, and I'm going to read it, my lord. My lord, your lordships have dealt with this matter even in the 239 AA first round of the Constitution bench. Any and every direction. What is the meaning of any in such constitutional provisions? Kyoto, my lord, is relied upon in the 239 AA by your lordships. In paragraph, it says, any can't mean every. Number 2-1B uses the word any direction. Kindly have a look at 2-1B. If he votes or abstains from voting in such house, contrary to, please mark the next word, any direction. So the argument raised was, Wherever any is, it would include every. Any has no other meaning but to be every. So this was pressed into service that the language is so clear. How can this be curtailed? Now, my lord, if your lordship now kindly see page 15, where para 13 of Kyoto is reproduced, Kyoto dealing with 21A says, literally meaning 21A means when you leave a party. When you leave a party, that is 13. 17, my lord, your lordships record the contention on intra-party dissent to remain a very, very important right of every elected member. Kindly now come to, my lord, 121 at page 17. 121. 44, my lord, your lordship may make a note. I am not reading it. I'll just bother your lordship from 121 and 122. Your lordship may also add 123 there, but I want to read these two. We may now notice one other contention as to the construction of the expression, any direction occurring in para 21b. It is argued that if the expression really attracts within its sweep every direction or whip of any kind whatsoever, it might be unduly restrictive of the freedom of speech and the right of dissent, and that therefore should be given a meaning limited to the objects and purposes of the 10th schedule. So, state question, my lord, and your lordships utilizes the, my lord, interpretation by limiting that power. Kindly see 122. While construing para 21b, it cannot be ignored that under the constitution, members of the parliament as well as the state legislature enjoy freedom of speech in the house. Through this freedom is subject, though this freedom is subject to the provisions of the constitution and the rules and standing orders regulating the procedure of the house, article 1051, 194.1, the disqualification imposed by 21b must be so construed as not to unduly impinge on the said freedom of speech of a member. This would be possible if para 21b is confined in its scope by keeping in view the object underlying the amendments contained in 10th schedule, namely to curb the evil or mischief of political defections motivated by the lure of office or other similar consideration. The said object would be achieved if the disqualification incurred on the ground of voting or abstaining from voting by a member is confined to cases where a change of government is likely to be brought about or is prevented, as the case may be, as a result of such voting or abstinence, or when such voting or abstinence is on a matter which was a major policy and program on which the political party to which the member belongs went to the polls. What was your manifesto? How did you go to the poll? What presentation you made? For this purpose, the direction given by the political party to a member belonging to it, the violation of which may entail disqualification under para 21b, would have to be limited to a vote. Now, kindly see, my lord, would have to be limited to, please mark this word one here, my lord, because these are only two situations. One, first, a vote on motion of confidence. That is number one. So it is limited to only two situations. One, when there is a vote of confidence in the house, and where the word starts, my lord, or it is two. Or two, no confidence in the government, or where the motion under consideration, I'm sorry, my lord, the second or, the two is where the motion under consideration relates to a matter which was an integral policy and program of the political party on the basis of which it approached the electorate. The voting or abstinence from voting by a member against the direction by the political party on such a motion would amount to disapproval of the program on the basis of which he went before the electorate and got himself elected, and such voting or abstinence would amount to a breach of trust reposed in him by the electorate. Kindly see, there is a coalition. They left the coalition. They got the votes on coalition. And the argument is made against us. The Vote is by the coalition. You are responsible for that vote which is given in your favor on that presentation. Therefore, my lord, dissent against the leader. So therefore, my lord, my respectful submission is this, that 122 restricts it to only two kinds of whips or direction which fall within the purview of 21B. There is no other whip or direction which your lordships have now permitted to be falling within the purview of 21B. I go a step further, my lord. If, my lord, there is a vote in the house, two situations can be there. There can be a whip, or it is absence of any whip. Can it be said, my lord, a whip to attend a particular meeting not in the house, outside, nothing to do with the vote or a policy? Can it be put in 21A if it doesn't fall under 21B? Because under 122 it doesn't fall under 21B. Any direction or a whip for any meeting outside, nothing to do with vote or these two categories. It doesn't fall under 21B because precondition for 21B is a whip or a direction, which gets restricted only to two categories. Now, these two categories, when there is no whip, can it be brought by any speaker to say, I will put it under 21A now? Impermissible. It would be abuse of that process and usurpation of a non-existent jurisdiction by the speaker. And they are raising it to a deem. There are two meetings of the party. In the present case, two meetings of the party, not for a house meeting for vote.
The merits of the matter, Mr. Malin.
I'm sorry, my lord.
These are on the merits of the matter.
I'm not on merits, my lord. I'm on the with utmost respect, my lord. I'm not going to the merits. I'm conscious.
This will only be in the context of merits only.
My lord, the judgment.
In the sense that speaker could not have gone into this issue.
I'm on the other, I'm deeply obliged, my lord, your lordships are pointing out to me. I'm conscious, I'm only answering because one of the judgments which they have relied upon is that any direction which is not complied with, therefore we are saying it is a per se automatic disqualification.
You are answering that per se point that even we should not decide in this manner.
I'm only, my lord, I'm respectfully only saying that judgment, my lord, I showed to your lordship that judgment also doesn't say so, because in your lordship may straight away come to at this point, my lord, kindly come to page 29 of this note. I'll come back a little later, my lord. Kindly come straight away to 29. I'll finish in, my lord, next 5-7 minutes. Kindly see page 29. My lord, repeatedly, my lord, an argument is made that for not attending the meetings and defying the direction on that account is per se disqualification. And kindly see at page 29, Srimant Balasaheb Patil's case, my lord, which is pressed into service again and again. Only 3 points on that, my lord. They had resigned from the party, those 17 MLA, number one. Number two, they failed to attend two meetings which were not 21B meeting. And three, failed to attend the trust vote, violating the whip leading to falling of the government. Not the other meeting. So your lordship said, in the light of these facts, we declare that this is the consequence. What I am highlighting and, my lord, pressing in service before your lordship kind consideration, define the whip for attending the trust vote in the house. That, my lord, this judgment doesn't have any applicability in our case. And, my lord, similarly, if you kindly see page 28, all the three cases, my lord, which have been relied upon, there is something more than not coming to the meeting. Kindly see, my lord, Ravi Nayak, the two members of one political party, MGP, supporting the chief minister of the other party. Then secondly, Mahendra Prasad Singh, he was elected on the Congress ticket and then as MLC and then goes as an independent, leaving that party. Similarly, Mala Rana, they say 13 candidates say, no, bring the Samajwadi party into power. And, my lord, followed by the Sriman Bala Sahib, there is a defiance of not attending the meeting in the house when the vote is to take place and the government falls. And last, my lord, my last submission is, kindly, my lord, come back to the judgment, my lord, of Yedurappa. My lord, at page 22. Page 22, my lord, of this.
Opportunity to Mr. Mehta today.
I'm finishing, my
No,
lord.
no, just, we just.
My lord, I am counting, my lord. I have only taken
We are just
approximately
asking whether
20
you
minutes.
give some opportunity today to him or tomorrow. That is.
Today, my lord, today. It's right.
Today.
It is on its way, my lord, today.
Right time to begin, Malak, for me.
Last word also.
It's very dangerous.
Very
time to
dangerous.
Begin, Malak.
True, true.
My lord, I knew at serial number 4, I will have this, my lord. Your lord,
Fits with the fading light.
your lordship,
No, you can.
enormous patience, my lord. I will not test it, my
No,
lord. I can't afford to do that. Only last submission, my lord, last.
No, you continue.
No,
My lord,
Ravindra,
the
having come this far, go ahead.
intra-party dissent, my lord, which became the subject matter of judgment in Yedurappa's case, my lord. It came from High Court, my lord. There was a dissent between two honorable judges, Honorable the Chief Justice and Justice Kumar. And then, my lord, Justice Kumar didn't agree with the Honorable the Chief Justice, Justice Kehar there, my lord. And the matter was referred to third judge. And your lordships, my lord, the Honorable the Chief Justice Kehar had held that they are two disqualified. The third judge agreed with the Honorable the Chief Justice. Justice Kumar's view was no, they have not been disqualified because they were opposing the leadership of Yedurappa. Your lordships accepted that judgment of Justice Kumar and my lord held that it was not a disqualification. I've only, my lord, taken the liberty to reproduce 2-3 paragraphs from Justice Kumar's view, which is para 45 and 62 at page 22 and 23, which I'm not reading. I want to read few portions of 3-4 paragraphs of your lordship judgment in Supreme Court in Yedurappa and thereafter sit down immediately. Page 22 and 23 of that note. 45 and 62 I'm not reading. Your lordship may just mark it. I only want to read 2-3 paragraphs in here. My lord, I will do it without even your lordship.
All right. Page 22 and
Yes,
23.
my lord. Kindly come to my lord. Para 122 again. They are not leaving us, my lord, para 122 from Koito to Yedurappa.
Although Mr. Suraj.
Yes, my lord. Although Mr. Sarabji was at pains to point out the language used in the matter was similar to the language used in Article 356 of the Constitution, which according to him was an invitation to the governor to take action in accordance with the said article. The same is not as explicit as Mr. Sarabji would have us believe. The constitutional process as hinted at in the said letter did not necessarily mean the constitutional process of proclamation of president rule, but could also mean the process of removal of the chief minister through constitutional means. On account thereof, the Bharatiya Janata Party was not necessarily deprived of a further opportunity of formulate a government, forming a government after a change in the leadership of the legislature party. In fact, the same is evident from the reply given by the appellants on 9th. In reply to the show cause notice is issued to them, they re-emphasize their position that they are not only continue to be members of BJP, but would also support any government formed by BJP and by any other leader other than Shri so-and-so of the state. The conclusion arrived at by the speaker does not find support from the contents of that letter. It so as to empower the speaker to take such drastic step as to remove the appellant from the membership of the House. 128. In arriving at such conclusion that by such short notice, no prejudice has been caused to the appellant since they had filed their detailed reply to the show cause notice, the speaker had relied on two decisions of this court, in Mahechandra Prasad Singh and Ravi Nayak, wherein it had held that 1986 rules were directly and not mandatory in nature, and as a result, the order dated 10-10-10 could not be set aside only on the ground of departure therefrom. Even if less than 7 days' time is given to reply to the show cause notice, the legislature must not be prejudiced or precluded from giving an effective reply to such notice. The procedure adopted by the Speaker, para 147, seems to indicate that he was trying to meet the time schedule set by the Governor for the trial of strength in the Assembly and to ensure that the appellants and the other independent MLAs to disqualified prior to the date on which the floor test was to be held. Having concluded the hearing on 10-10-10, by 5 p.m., the Speaker passed a detailed order in which various judgments, both of Indian Court, Foreign Court, and principles of law from various authorities were referred to on the same day, holding that appellants had voluntarily given up their membership of BJP by their acts and conduct, which attracted the provision of 2(1)(a) of 10 schedule to the Constitution, whereunder they stood disqualified. The vote of confidence took place on 11-10-10, in which the disqualified members could not participate, and in their absence, Shri so-and-so was able to prove his majority. Unless it was to ensure that the trust vote did not go against the Chief Minister, there was no conceivable reason for the Speaker to have taken up the disqualification application in such a great hurry. Although in Dr. Mahechandra Prasad case and in Ravi Naik's case, this court had held that the disqualification rules were only directory and non-mandatory, and that violation thereof amounted to only procedural irregularities and not violation of a constitutional mandate. It was also observed that Ravi Naik case that such an irregularity should not be such so as to prejudice any authority who is affected adversely by such breach. In the instant case, it was a matter of survival as far as the appellants were concerned. In such circumstances, they deserved a better opportunity of meeting the allegations made against them, particularly when, except for the newspaper cutting said to have been filed by Shri so-and-so along with the disqualification application, there was no other evidence at all available against the appellant. Having considered all the different aspects of the matter and having examined the various questions which have been raised, we are constrained to hold that the proceeding conducted by the Speaker on the disqualification application do not meet the twin test of natural justice and fair play. The Speaker, in our view, proceeded in the matter as if he was required to meet the deadline set by the Governor, irrespective whether in the process he was ignoring the constitutional norm set out in the 10th schedule to the Constitution and the disqualification rule, and in contravention of the basic principle, and go hand in hand. The appeals are allowed. Order of the Speaker was set aside. So, my lord, this is the test which your lordships have laid down, and my lord, therefore, I appeal to your lordships, my lord, that this case, my lord, with your lordships now deciding on that day of deference of, my lord, consideration to refer the Nabam's decision to larger bench. Insofar as the other points are concerned, nothing would survive, my lord. That's our respectful submission. It is only academic, especially, my lord, when the gentleman concerned did not face the vote of confidence in the House. That's our respectful submission, my lord. Deeply obliged. So
thank you, Mr. Mahendra Singh. Mr. Mehta, how long would you take?
1 hour outer limit, maybe 5-10 minutes more.
Right. So by between 11 and 12, we'll give you an hour tomorrow. Mr. Sibbal, how long would you take after that? Between you and Dr. Singh?
I don't think so, Malas. I'll take the end of the day because 5 days have been taken this side, Malas. I might just respond.
But now I think we have to wrap
it up. Best bets is your lordships tell me which are the areas your lordships want clarification. I'll answer it. There's no issue. I have no
what
problem.
You can do is, Mr. Sibbal, you can start your rejoinder, and then if you feel that we can go to the next point, we'll tell you that.
There's no issue, Malas. I didn't trouble your lordships on the earlier occasion. I won't trouble you again, Malas. I'll just answer all the questions.
But if possible, it would be good if both you and Mr. Dr. Singh, we can.
That may not be possible, Malas. That may not be possible. That may not be possible. Your lordships have been so very
10
patient.
Minutes of Mr. Kamath or 10 minutes of the clock?
By the clock.
Your lordships have been so very patient, Malas, with all of us.
12 o'clock we'll start tomorrow.
Yeah, that's fine.
11 o'clock to 12 o'clock, Mr.
12 o'clock
Mehta, and 12 o'clock for your rejoinder.
No issue.
12 o'clock will start.
Please. Okay.